that it defeats a constitutional right of citizens to know who is funding these political parties. That's a fundamental right which your lordship has recognized under 191A. And my right to privacy about which political party I am donating to overrides the citizen's right to information, to know about who the political party is getting funded from. That money can still flow through electoral bonds in this way. You have converted black money and deposited it into a tax haven bank account of some company registered in a tax haven. You then transfer that money you set up a subsidiary in India, transfer that money to a subsidiary in India. That subsidiary company, because you have removed the limit of 7.5% also, even if it's a shell company. So the first argument of the solicitor was that because of these amendments, the volume of cash which is coming to political parties, which he says are maybe black money or is likely to be black money, that has gone down.
No, that's not his argument. He doesn't make a quantitative statement. His contention is that this was an effort which was made to bring into the accountable channels what was otherwise completely beyond the fold of accountability because the earlier schemes had not worked.
So let me just deal with that. Firstly, my lord, it did not close the cash channel. The amendment has left open the cash channels. The only change that has been made is that for getting income tax exemption, that 20,000 has been brought down to 2,000. That's all. Otherwise, donations up to cash donations up to 20,000 can be given to political parties, and they are not required to be reported. Quite apart from the fact that actually 20,000 or 2,000 does not make any practical difference, because all that the political party declares is, I have received X crores as cash donations, which are below 20,000. They used to say below 20,000 earlier. Now, if they want to avail of income tax exemption, they say it's below 2,000. So they say that we have received whatever, 100 crores, 500 crores by way of petty cash donations. Earlier, petty meant below 20,000. Now, petty means below 2,000 if you want to avail income tax exemption. Practically, it makes no difference, in my respectful submission, to the availability of cash to political parties or the ability of individuals to give cash to political parties. Practically, that 2,000, 20,000 makes no difference. Now,
that will not impinge upon the validity of the scheme.
Yes, I know. Lord, they are saying that this whole exercise was to bring down the element of cash in the economy. They say cash is equivalent to black money. The object of the exercise was to make political funding of parties to come more through banking channels rather than cash. This, they say, was the stated purpose of this whole bringing in electoral bonds, one of the stated purposes.
Mr. Bhushan, there will be slight difficulty. Even if it has not happened, probably the data may support you. The cash channel may not have come down.
No, cash did come down. I'm not saying cash didn't come down, but the reason why, it's important to understand why cash came down.
There are three, four arguments on which we want direct answers. Yeah. One is that the intention was to ensure that the money comes through regular banking channel. Yes. There is a KYC required.
Yes.
Which is not there as far as payment cash is concerned. Yeah. And also, even if it is coming through the bank accounts.
Yes.
The KYC by the second KYC at the time when the bond is purchased is a second added advantage.
All right. Let's assume that that's there.
Number three, their contention is that as far as payment is concerned, the person who's made the payment is concerned, the need to know the name of the donor has been protected. The confidentiality of the donor has been protected.
Yes.
For 1, 2, 3, 4 reasons.
Yes.
And therefore, when you are examining the reasons, you will have to take into account what was the intent behind the enactment, and not by a counter argument, which may be. And there has always been a conflict between confidentiality and declaration, or
So, my lord, in
both of them have their pluses and
Yes.
minuses.
to answer our argument that these changes defeat the citizens' right to know about who's funding the political parties because they introduce another anonymous source of funding. Now, the answer given by the solicitor to that is that, well, it had an objective. Now, these are two conflicting things. They say the objective was to limit black money or cash money coming to political parties or to reduce that. And therefore, we introduced these electoral bonds because many individuals or companies do not want to be known that they are the donors to these political parties because they fear victimization. So that was what the finance minister then stated. That's the argument also of the solicitor, that there was an objective behind this. Now, what I'm pointing out is that if the objective was to choke off cash donations have not been choked off.
But that was not the object at all.
Yeah.
The object, as the finance minister says in that article, and that's broadly an indication,
Yes.
was to add some element of transparency. That's what Mr. Jaitley said, that it will enhance transparency to a significant extent, and we would add two separate phrases which have been used. That's the point. You're right. In the earlier regime, absent this, it was purely cash based. You had those options, voluntary contributions, you had electoral trusts. But
not just that, you had direct check donations, etc. That is
a cash based scheme, an unaccounted scheme, proceeds on anonymity.
Yes.
According to you, they have continued anonymity.
Yes.
But
they have continued that anonymity
but
of
there is
cash.
but there is
well
one
as-
change.
Yes.
But there is one change.
Yes.
That the electoral bonds have brought whatever is contributed to the electoral bond in the form of accounted transactions within the normal banking fund.
Now the question. So that's the second limb of the argument, that this reduces black money flowing into political parties because it's coming through banks. Ultimately,
Whether it reduces or not, to my mind, is irrelevant to the validity of the scheme.
all right.
The scheme may be wholly unsuccessful, but it may still be a constitutionally valid scheme.
No, Lord, then that is no response to my original submission, which is that it defeats a constitutional right of citizens to know who is funding these political parties. That's a fundamental right which your lordship has recognized under 19(1)(a). And if what is being argued, that the object of this bringing in electoral bonds was to reduce cash and reduce black money, so to say, and bring in only accounted money through banking channels to political parties, if that's the argument, then I'm just pointing out that that's not entirely correct for the reason. Firstly, you can still give cash. There is no bar today which has been placed on cash. The only change that has been made is simultaneously.
But how do you put a bar on cash? It's a third economy. Much as you may impose a bar on cash, it's illegal. But you have a third economy.
That's the point, my lord, that it could easily have been done that all receipts of political parties, at least of political parties, will have to be accounted, whether it is cash or not. All cash also, any money being received, you could have done either of two things. One is to say cash is totally prohibited, you have to take through banking channels. This is one option. The other is, even if you take cash, irrespective of the amount, even if it is 100 rupees, 50 rupees, even the RBI, when it dealt with this electoral bonds, when it responded to electoral bonds, they said that if your object is to make political funding go through banking channels, there are existing instruments of checks, drafts, bank transfers, etc., which are available. Why are you introducing this anonymous instrument? This will allow, because as I pointed out, Lord, it's not that black money cannot come in through electoral bonds, though it will come in through banking channels. The example that I had given in my initial submissions was, suppose, as has been done, that you, by under invoicing, over invoicing, etc., you siphon out some funds, X crores or X thousand crores, to tax havens. From there, my lord, you have a company to which you have deposited. That's all black money. It's over invoicing, under invoicing money which has been siphoned out to those tax havens. You set up a subsidiary of that foreign tax haven company in India. It's a subsidiary under the FCRA changes. It was argued, my lord, FCRA is not in question here. But FCRA changes have been challenged in this very petition also, 2016, by which the availability of even subsidiaries of foreign companies to donate to political parties was brought in. And whether or not your lordship decides on the validity of that or not, your lordship have to keep in mind the fact that simultaneously that route was opened up. The route of subsidiaries of foreign companies donating to political parties was opened up. Now, what I am pointing out is black money can still flow through electoral bonds in this way. You have converted black money and deposited it into a tax haven bank account of some company registered in a tax haven. You then transfer that money to, you set up a subsidiary in India, transfer that money to a subsidiary in India. That subsidiary company, because you have removed the limit of 7.5% also, even if it's a shell company.
Mr. Bhushan, at a constitutional level, this argument won't wash. I'll tell you why.
I am only responding to what was argued, my lord. I am not.
This will not wash. This
of subsidiary company.
This will not wash at a constitutional level for the simple reason that the fact that they have been unable to, or they did not, dry all cash sources of funding of political parties is not an answer, there is not a ground to challenge the validity of a scheme.
I'm not using that ground. I am saying that the response of the government to my grounds. What were my grounds, my lord? My ground was Article 1918 defeats the rights of the citizens to know the funding of political parties. Number two, my lord, it promotes corruption because it effectively legalizes corruption because it allows any company to give anonymous kickbacks, legalized anonymous kickbacks to the parties in power. And I pointed out that the evidence, there is considerable evidence to show that almost all the electoral bonds have gone to ruling parties. Vast bulk to the ruling party in the center, the rest to the ruling parties in the states. And virtually all the electoral bonds that have been purchased are in 94.5% in denomination of 1 crore and the remaining in denomination of 10 lakhs, virtually nothing below that. Therefore, there is good reason to suspect. And I gave two examples also. I'm not saying that your lordship should use those examples because those parties, those companies are not before us. But I gave those two examples. One company has declared officially that they gave those electoral bonds to ward off excise issues which had arisen with the government. The other company who has purchased electoral bonds worth more than 450 crores from their accounts declared to SEBI has been the recipient of several mining contracts and various other favors.
You already argued, Mr. Bhushan. You're in rejoinder.
These are all auctions. Mining contract,
You're in the rejoinder now.
Kickbacks. You participate in all.
Don't re-argue your case.
I'm not re-arguing. I'm just pointing out that that's my argument. Now, what is the government's response to that? So how do they answer this question that this defeats the citizens' right to information? One answer that they have given, I was coming step by step. One answer that they had given was that there was a competing interest of bringing down cash or bringing down unaccounted money into the donations and finances of political parties. I am just answering that issue. The other argument that they have made is that there is a right to privacy. That's the argument made at the end. Firstly, my lord, the right to privacy doesn't extend to companies. It's an individual human right. Even in Puttaswamy, your lordship have laid down that that's an individual's human right. It's not a right of a company. So therefore, so far as those amendments which have been made to the Income Tax Act, to the Companies Act, etc., which anonymize donations by companies to political parties and remove the requirement of declaring who you have donated to or where you have spent this money, that right cannot be invoked for companies. The right of privacy cannot be invoked for companies. And even otherwise, my lord, if let's assume that there are some individuals who are giving this money, the question is, can those individuals claim a right to privacy which overrides the right to information of citizens? Even under the RTI Act, if your lordship recall, there is an exemption for privacy. There is an exemption for personal information. But that exemption stated that only that personal information which has no bearing on public affairs and which cannot be overridden by public interest is exempted. If there is a public interest override, even that information is not exempted. So in my respectful submission, my lord, that privacy argument cannot be used to say that my right to privacy about which political party I am donating to overrides the citizen's right to information, to know about who the political party is getting funded from. So that right, my lord, in a clearly would override, even if there is a right of privacy of an individual. Of course, companies don't have that right, but even if an individual has that right of privacy about donating what they have donated to political parties, in my respectful submission, that is overridden by the citizen's right to information. The other argument that was made was, again, on the basis of what the finance minister had said. It was argued that this is to prevent victimization. Now, firstly, as your lordship pointed out, the government would certainly know, or the party which runs the government can find out, look, this company had purchased electoral bonds worth 100 crores. We have not received anything from it. Therefore, obviously, they have given it to the opposition parties. And therefore, that much information which will still allow the government to victimize that company is always available with the government. Even if they do not use their control over the state bank to find out which company has given electoral bonds to which party. The argument that was made was that no, there is an elaborate system of protecting that information. It's very simple, my lord. Obviously, when a person purchases an electoral bond, he gives KYC, etc., the bank would have to record that this person or this company has purchased this electoral bond, and the number of the electoral bond would have to be recorded somewhere. Thereafter, my lord, when a party encashes that electoral bond, the number of the electoral bond which that party has encashed would have to be recorded. Otherwise, my lord, it would make it open for counterfeiting. And therefore, you have to record these two informations. So therefore, it's not so difficult. If the government wants, State Bank of India would certainly know. And if the government exerts sufficient pressure on the state bank, they can come to know. Even otherwise, my lord, the government would know as to which companies have purchased electoral bonds worth how much and that we have not got it.
So one point is, of course, you have highlighted the citizens' right to know. What is the next?
Right to know that the sphere of that the justification for victimization, etc., doesn't really apply. In fact, it's only the citizens who are being deprived of this information. Each political party would know, can know, and certainly the government can know. A citizen cannot, my lord, scan the.
Mr. Bhushan, I think point in rejoinder.
And then, my lord, just two more things. There was an interim order, as your lordship saw,
Yes,
asking the
12th of
Election
April,
Commission. I am respectfully saying because they are going to open electoral bonds window for this state assembly elections any day now. It can be open tomorrow, it can be open day after. And again, my lord, till today, till March 2022, electoral bonds that had been purchased were over 9,000, under 10,000 crores. Till today, I understand that the electoral bonds that have been purchased in this last 1.5 years has taken the total to 13,000 crores. Now, today, if they open the electoral bonds, again, in this assembly election, again electoral bonds will go. I am respectfully, my lord, requesting your lordship, even if your lordship does not stay the issue of electoral bonds after today, at least one thing your lordship should say, that it should be made clear to the parties who are purchasing electoral bonds that these may be subject to disclosure. Because this court has the power under the scheme also to seek information from the State Bank of India. And I am requesting, my lord, that at the end of this, if your lordships agree with us that this electoral bond is unconstitutional, etc., then your lordship should disclose as to which company has given to which party, etc. And even if that information has to be obtained from the State Bank of India. And that's why, my lord, I'm saying that at least today, because last time the same thing happened in that Election Commission appointment case. I had an interim application. I mentioned that interim application on Thursday on saying that there is one post vacant of the Election Commission. And the court is proposing.
Except for the difference, except for the fact that after the 12th of April 19 order,
Yes.
when you moved a fresh IA for stay,
That was for that particular.
that stay was declined by the then
Yes,
judge.
yes, that was at that stage
Mr.
for
Bhushan,
that particular.
That's why I asked,
bond.
what is exactly your prayer? You asking for quashing of the?
Of course, I am asking for quashing.
Just 1 minute. Are you asking for quashing of the scheme, or you want that the disclosure should be made?
No, I'm asking for quashing of the scheme.
Okay, therefore, you had
anonymous
to answer that question.
And in case your lordships.
Mr. Bhushan, just one more question.
Yes.
The scheme has one advantage. There's a KYC at least. You will accept that there's an advantage in that.
No, that's all right. If the anonymity is removed, I have no problem.
So therefore, you argue on that.
I'm saying I'm challenging the scheme because of the anonymity. Remove the anonymity, I have no problem with electoral bonds. I'm challenging the anonymity of the electoral bonds. So that is defeating the right to information of the citizens.